The United States has 94 federal district courts, one in each state, and additional districts covering D.C., Puerto Rico, and other territories, designed specifically for hearing cases at the federal level. In the fiscal year of 2024, the United States Sentencing Commission reported a total of over 61,758 federal criminal cases. That is just over 170 cases a day, every day of the year. But why does that matter? So what? In fact, the United States District Judge Marvin Aspen describes the right to a trial by a jury of one's peers as the hallmark of our judicial system and an essential feature of our democracy as a whole. It was the belief in that very right that led to the establishment of our country. So, whether we're glancing at the news for updates on the latest controversy in trial or sitting down for jury duty, the federal criminal justice system is heavily intertwined in our lives. Today, I will walk through the 3 key stages of a United States federal criminal trial: before, during, and after, so that next time those headlines come up or duty calls in the mail, everything is crystal clear. First, before the trial even begins, there are many parts of the pre-trial stage that must be taken care of. For starters, if a crime is brought to the attention of federal authorities, the FBI's brief description of the federal criminal process informs that a federal law enforcement agency will undertake an investigation to determine whether a federal offense was committed, and if so, who committed it. This is because not every crime is necessarily a federal offense. So, a crime is only prosecuted in federal court if, for example, it crosses state or national borders or involves federal officers or property. So, for example, while murder is obviously illegal in all 50 states, it will only be prosecuted in federal court if, say, for example, it involves the murder of a federal officer on duty. Once investigators gather evidence, there has to be a finding of probable cause, and this is where a grand jury comes in. A grand jury is a group of 16 to 23 citizens who hear evidence presented by prosecutors and decide whether there is probable cause to formally charge the defendant. If they agree, they issue an indictment, which is essentially the federal equivalent of saying, yes, this case can move forward to trial. If a grand jury is not used, though, the judge may choose to elect a preliminary hearing instead. Unlike a grand jury, at a preliminary hearing, the defense attorney is welcome to show up and contend a lot of the evidence presented by the prosecution. However, a lot of most federal felony cases in practice do go through a grand jury indictment. After the indictment or preliminary hearing, the defendant appears in court for arraignment, which is where the formal charging happens and the defendant enters into a plea. From here, the case moves into the stage of pretrial motions. As defined by the American Public University's Overview of Criminal Law, pretrial motions are requests that lawyers file to shape the trial before it begins. For example, the defense might file a motion to suppress evidence that's been obtained illegally, or file a motion to dismiss charges that they find invalid. These motions are crucial because they set the boundaries for what the jury will eventually hear. So, once investigators, grand juries, judges, and lawyers have done all the groundwork, the case finally reaches the moment we picture most: the trial itself. The trial stage is where everything unfolds in the courtroom. The Department of Justice notes that it begins with jury selection, otherwise known as voir dire, French for to speak the truth, which is where the judge and attorneys question potential jurors to ensure impartiality. After the jury is seated, both sides deliver opening statements, giving the jury an outline of what they intend to prove. Then comes the presentation of evidence. The prosecution goes first, calling witnesses and presenting documents, following by cross-examination from the defense attorney. So, over the last year, I have become a member of my high school's mock trial team, which involves presenting evidence in court when we compete. So, at my previous year's case, I had to present tire marks, ropes, toxicology reports, and receipts before I could make a lot of my arguments. It's one of the most fascinating parts of the process. Once the government rests, the defense may present its own evidence or simply argue that the prosecution failed to meet its burden, which is proof beyond a reasonable doubt that a crime took place. This back and forth is the heart of the trial. According to legal clarity, every piece of testimony and cross-examination is meant to help the jury decide what really happened. Finally, each side delivers closing arguments, and the judge instructs the jury on the law. Once the courtroom arguments close, the responsibility shifts from the lawyers to the jury, and the trial enters its final stage. After closing arguments, the jury deliberates in private. Their job is to review the evidence and reach a unanimous decision. If the jury finds the defendant guilty, the case moves to sentencing. However, we are not done yet. Even after sentencing, the process is not over. Defendants have the right to appeal to a higher federal court. Appeal courts do not retry cases, but instead look to see whether or not some legal errors were made and have the option of changing the verdict, if they do think that legal errors were made. It's safe to say that the federal criminal trial process is absolutely fascinating. So, we've now talked through the 3 stages of a federal criminal trial. Before the trial, we choose whether or not the trial will move forward. During the trial, attorneys make their case, and after the trial, the jury delivers a verdict. In other words, the federal criminal trial process before, during, and after is the framework of our justice system. So, next time there is breaking news about a federal case or there are jury summons in the mailbox, I hope it is easy to recognize exactly what stage the process is in. Understanding these steps makes the federal criminal justice system less of a mystery and more of a civil process for all of us. Thank you.